So good evening. We'd like to call the meeting to order, but just going to suggest that those of you who may be members of, like, Paul Tilka, that was interesting. So Kurt, was that the signal that you're in your room now?
I had nothing back here.
And we didn't buy the generator yet, right? It's been a temporary brownout for 2 seconds.
So,
The members to sit in the front row.
so Jerry as a member and Paul Tilka as a member of the Charter Committee, we have John and Grace in the front row, so we're,
Jerry and Paul, if you can.
Paul, could you sit in Jerry in the front row so we could, thank you. Embarrass you? No. Thank you. So we'll call the meeting to order. This is the Monday, December 3rd,
Oh, my gosh.
Citizens Forum for the Charter Amendments. And so we're going to ask Andrea to call the roll, please, of the members of the Charter Committee.
Okay. Jerry Clyott? Here. June Munns? Absent. Paul Tilka? Doreen Moore?
Here.
Attorney Brooks?
Present here.
Mr. Hendricks?
Grace Critelli. Grace Critelli.
Oh, sorry. Grace Critelli, I'm so sorry.
So what we'll do is move forward into citizens' input regarding the charter amendments, and we would ask Attorney Brooks to go through these particular proposals item by item.
Thank you very much. Where we are, for the public who's watching on television and for the public that's here today, is after a meeting as the Charter Review Committee and coming up with a number of proposed ballot questions and charter amendments. The committee has prepared these changes and are making them available to the public for public comment tonight in a citizens forum. That means we'll go through each question one at a time as they would appear on a ballot and stop with each question, take public comments, concerns, questions, ideas, open the floor up for each question individually. After we hear ballot 1, we'll move on to ballot 2. After ballot 2, we'll move on to ballot 3 until we finish. And we're looking at 15 ballot questions this evening.
Should we, before we start, possibly give the format of what happens next? In other words, the committee has met, we make these recommendations, it goes to the BOC, just for the general public to understand the process.
Yes, I think we have a meeting scheduled for December 6th, this Thursday at 6 p.m., a workshop in front of the Board of Commissioners where the Board of Commissioners will consider the charter amendments that we're going through this evening. Of course, the Charter Review Committee makes recommendations to the Board of Commissioners, but the Board of Commissioners has the final say as to what goes on a ballot and what may not go on a ballot, and they have the power to change any of these ideas. So that's another purpose of having this citizens forum prior to the Board of Commissioners considering the charter questions.
So it goes from the workshop on the 6th, it could be tweaked, they make their they don't make recommendations at the workshop, but they're reviewing it, and then
It'll go for a first and second reading to be placed on a ballot, and then the ones that pass by a majority of the voters in an election will become actual charter amendments that would become effective.
And the purpose of this is to move this forward into the March 12th municipal ballot.
Yes, March 12th, 2019.
Okay, thank you.
Ballot question 1. This charter amendment would require a simple majority of a quorum or members present and eligible to vote instead of 3 affirmative votes for most actions of the Board of Commissioners, including ordinances, resolutions, and other routine actions of the board. The current charter says it requires 3 affirmative votes. That has been a problem when we have a quorum of just 3 people. That means that a vote on that item would require a unanimous vote. So this would be a simple majority of a quorum that appears for a meeting for most items, absent some other charter provision that would require a supermajority vote. Are there any questions, comments, or concerns regarding ballot question number 1? If you have a question, come on up to the dais, the microphone, and that way they can hear you on television as well as here in the audience.
Hi, I'm Helen Palladino, 13319 Boca Ciega Avenue here in Madeira Beach. Just a question, since I don't know this. What happens when, okay, this is if we only have, 4 commissioners show up for a meeting, right?
Well, it's a simple
Or less?
majority vote, no matter how many you have. If you
So it's-
have 5, a majority would be 3. If you have 4,
Majority would be
majority
3.
would really be 2, or actually 3 to pass, because otherwise you'd be tied at 50-50. If you have 3, then
So
it'd
2
be 2.
commissioners would have to be not present in order for 2 people to pass something. Then if only 3 people showed up, 3 commissioners showed up, then a majority of 2 could pass something, is what you're
If
saying.
5 commissioners appear at a meeting, it would require 3. If 4 appear at a meeting, it would require 3. If 3 appear at a meeting, it would require 2. If 2 appear at a meeting, there's no quorum, so no action can be taken.
What happens now when only 3 commissioners show up?
You need affirmative 3 votes of all 3 commissioners to pass an item.
So it doesn't get voted on, or it gets voted on and it could fail?
It gets voted on, but requires a unanimous vote if only 3 are there.
Okay. Is there a mechanism where a vote can be postponed to the next meeting?
A motion to postpone, or a motion to table, or a motion to continue. Could postpone to a time, date certain, or to table until pulled off the table by a Roberts Rule motion.
As long as you've been our city attorney, have we ever had to do that?
Oh, I don't remember specifically. I don't think so.
Okay. Never had to, okay. Okay, thanks. Put that right here.
Any other questions on number 1? Ballot question number 2 would establish a new term limit. This charter amendment would amend the charter to establish a consecutive term limit. The mayor and district commissioners shall serve no more than 3 consecutive regular terms and shall not seek re-election for a period of 2 years for either mayor or district commissioner. Should the charter be amended, yes or no? Are there any questions, comments, concerns about ballot question number 2, establishing term limits? Moving on to ballot question number 3, forfeiture of office for knowing violations. This charter amendment would provide that a commissioner shall forfeit office if the commissioner is found to have knowingly violated the sunshine laws, ethic laws, or public records laws. Should the charter be amended, yes or no? Are there any questions regarding ballot question number 3? Yes.
Helen Palladino again, 13319 Boca Ciega Avenue here in Madeira Beach. Do we have a definition for knowingly?
No.
How do you prove someone knowingly? That's hard.
Knowingly is a typical standard you would find in a criminal court, not in a civil court. In order to show a violation of a crime, for instance, you have to show mens rea, that you knew you were violating the law. So sometimes it is difficult to show a knowing violation, for example, of a sunshine law. It could be inadvertent, unknowing. It's also difficult to show a knowing violation of an ethics law violation, or even a public record law. So you'd have to show that the person knowingly knew that they were violating that law, and that's more difficult to show than an inadvertent violation.
And who shows that? Who would prove to me that one of our commissioners knowingly violated the Sunshine Law.
That'll come up in ballot question number 5.
Okay.
It's going to be decided by, if ballot number 5 passes, it would be decided by a special magistrate. Right now, the charter is silent as to who decides it.
Okay, as long as somebody's doing that.
Could making one comment is found to have knowingly violated. In other words, were they found, quote, guilty of sunshine law, ethics laws, or public record laws? And
By
when
the
the
magistrate.
discussion was had,
Right?
well, the discussion was had by the committee of the fact that sometimes there could be an inadvertent, and you could still be in violation of, giving you the example of public records. You know, you overlooked turning over something, it was not intentional, it wasn't hidden, and that was where the term knowingly, as opposed to, so inadvertently, as opposed to intentionally withholding or intentionally having committed.
I think the other example that was given too was if the commission was meeting here and they did a ballot a certain way and the ballot violated the sunshine law, but they voted anyway based on the advice of the city attorney saying it was okay to vote, then that probably wouldn't be a knowing violation if they were following the advice of the city attorney.
Have we thought, has the committee thought forward, at the rate sunshine law violations are thrown around in this city, have we thought about what's going to happen when we pretty much dismiss or have multiple commissioners resign based on someone's idea that they were found to have knowingly violated the sunshine law?
Yeah,
I mean,
that's
are we
why
going to have backups or something? Because
Originally, it did not have knowingly in there. And so to try to stop gotcha moments or inadvertent violations, to narrow it to just those knowing violations would be grounds for forfeiture. So because there are so many allegations of sunshine law violations, this would just be those that are found to have been knowingly committed.
But
and
also,
and knowingly would be determined by the magistrate and not by the administrative law judge who's hearing the case. Is that how I understand it?
Not by an administrative law judge. If there was a sunshine law violation or a Public Records Act violation that was brought by the state attorney, for example, in criminal court, and the criminal justice judge found that you knowingly violated the sunshine law and assessed a penalty, or the ethics commission found you knowingly violated the sunshine or ethics law and had in their order a statement that it was a knowing violation, that would be have found to have knowingly violated the sunshine law, ethics law, or public records law. Any arguments about whether it was knowing or whether those prior decisions apply under ballot question number 5 would be made by a special magistrate rather than by the Board of Commissioners themselves about their own commission members.
Okay. So I guess 3 ways someone could be knowingly, have found to have knowingly violated. So we got the magistrate, the special magistrate that can do it, the judge that does the hearing, and the ethics committee, I guess, that does this up in Tallahassee. So again, at the rate these accusations fly around this city, are we going to now ask these 3 entities and individuals to make such a finding with every violation that comes before them so that we can throw a commissioner out? Or
That is one.
I can see it
that is
being
one
used
concern,
very
yes.
poorly.
The state attorneys prosecute them at the criminal court. The state of Florida prosecutes them at the Commission on Ethics. Those are separate and apart from the city's own process. If one of those, the judge or the Commission on Ethics makes a finding, then that finding would then go to the city's special magistrate to see if it qualifies under this amendment for forfeiture of office. If it does, then there's a procedure set forth how they would be removed by the special magistrate from the city commission.
So there has not been any kind of thought about what happens when several commissioners,
Well, there has been thought.
have got to
It is a
forfeit their
concern that
office.
you
Oh,
could have one or more forfeit. There is a procedure for replacement of commissioners that's in the existing charter. I don't believe we're amending that. We'll see as we go through here.
okay.
I just would like to say that this is not the committee's intent to create ways for people to go on a witch hunt. The sunshine laws.
Well, we
are
already
there.
do that.
The eth-
So now
Well,
we've got
but-
some teeth in it.
Well, the sunshine laws are
Yes, we do.
created by the state
We
of Florida.
are constantly throwing the violation of sunshine laws out against
Anybody can
commissioners and
say
everybody
anything that they want
who has
about
ever sat up
anyone.
there.
But the point is that the mechanics or the mechanisms of how these three types of public records laws, ethics laws, or sunshine laws are already established by the state. That's not up to us to determine or try to be judge or jury as a.
Right, you just want to kick them off the commission. Well, that's the result of this ballot question, right?
But
The
if
whole
someone
purpose of
if
this
if
is to make
someone
them
is found
resign,
To have, yeah, okay,
right?
thank you.
Hey, I totally understand, and I would venture to say a vast majority of them are just errors or mistakes. But what I'm worried about is a group of people targeting somebody, creating this, charge against them, having it set up so that the magistrate, if the administrative law judge doesn't find that they had the intent to do it, and if the ethics committee head didn't find it, now we have a magistrate that could find it and kick people off.
Can we make sure that when
I'm
one
reading this for
person
the
is
first time.
talking?
It's just
that-
my impression.
Excuse me. When we're talking and answering from the floor to the committee members, if we could hand the microphone over to the committee members because they can't hear what they're saying
Okay.
on television.
If you use that microphone and you would hand to the.
Well, let's
other-
just use one microphone, and that way it ensures that only one person is speaking also at the same time.
Well, why doesn't the person come up then? Okay. Thank you.
So, in response to that too, I think did want to clarify that you could have findings by the Commission on Ethics of an ethics violation that's not knowing. You could have a circuit court find that there's a sunshine law violation, but not find that it's a knowing violation. Those would not be grounds for forfeiture. Only the ones that are a knowing violation is how this is structured, and that's how the committee wanted it worded.
I know, but now we are going to ask those three entities or persons to make a finding, right? To make a finding whether it was knowingly or not.
A special magistrate will look at to see, in a particular case, whether there's a finding of a knowing violation. So, and it could either be done by a judge or the Commission on Ethics, where they'll pick up the orders of those other branches of government and say, yep, they found a knowing violation. Therefore, there may be grounds for forfeiture, and there's a procedure. There are other cases that may not go to the Commission on Ethics, may not go to the circuit criminal judge or circuit civil judge, but could be raised by a commissioner on the dais with the motion of a second, and then they'll have an evidentiary hearing, and the special magistrate would have the final decision, not the commissioners.
Correct.
Hopefully
Could
to
we
remove.
allow-
But it would never get to
hopefully
the
remove
magistrate if
politics.
the administrative law judge found knowingly,
No, it would have to go to the special magistrate.
regardless of what the ethics committee or what the judge found.
The ethics committee order would be stapled together and taken to a hearing and handed to the special magistrate, who would then make the final decision under ballot question number 5. Number 5 says that the commissioner can either, we'll jump to that for a second, may within 5 business days either request a special magistrate hearing or resign. And then the special magistrate has to hold a hearing within 30 days, if it's requested. So say a judge or the Commission on Ethics found a commissioner knowingly violated the ethics law. A Board of Commission member could then say, there's an order from the Commission on Ethics finding a knowing violation. I recommend that we send this to a special magistrate for a forfeiture. If that's seconded by the commission and you receive a majority vote, it goes to the special magistrate. And the commissioner can either resign or go to a hearing, and they have that
So-
option.
So the magistrate could find that someone did not knowingly violate the Sunshine Law, Ethics Law, or Public Records Law, even though the Ethics Committee found that they did?
I don't think so, but you would, it
Or
could happen
would the
in a
magistrate
particular
just rubber
case.
stamp whatever?
It might be what they call in the law res judicata or collateral estoppel. It's already been decided by a judge or by a commission on ethics, so the special magistrate would take that into consideration. But they would also listen to any other defenses that the commissioner might have.
Could we
But they've
pass?
probably
We have
already
other
been considered.
questions.
Someone else want to speak?
Yes.
Come on up.
I'm just trying to figure out, Linda Hine, 401 150th Avenue. I'm trying to figure out, we already have something in the charter for forfeiting your office if you have a violation. So isn't that correct? There's something in there already about it, but the word knowingly is the new part, or what else is new?
That falls under number 5. We've reworded number 5 as well as a committee, making the recommendation that this would be clarifying the next step if the elected official were knowingly found to have knowingly violated one of those 3 areas with the mechanics that's already in place under the state laws.
So basically, the knowingly part is the addition to what is going to be added. Okay, I was just trying to figure that out. Thank you.
Let me just
Wait.
verify that before we go forward. I think this entire section is new to the charter, but I will review that and make sure, and then let us know for sure at the Thursday Board of Commissioners workshop. But I believe this entire section is new. But I think they discussed knowing versus not knowing, and the concept was that only knowing violations should result in forfeiture, because otherwise there could be inadvertent mistakes, and there could also be witch hunts and gotcha scenarios and people trying to set up people for sunshine violations that they did not knowingly commit. There's,
Commissioner Weinstein, we don't have a moderator. Pass the mic to Debbie.
My name is Debbie Weinstein. I'm speaking as a citizen. My address is 441 129th Avenue. So what happens if ballot question 3 passes and ballot question 5 does not? Then it's left back to 2 options.
ballot question 3 is simply about the grounds for forfeiture. And this would be an additional one for knowing violations of sunshine ethics law and public records law. Ballot question 5 is separate, and we'll get that to it in a minute. If ballot 5 does not pass, then the existing charter language remains the same, which is relatively silent about how forfeitures would be conducted.
Okay,
So a motion by a commissioner, a second by a commissioner, and the commission conceivably holds its own forfeiture hearings and puts on trial one of its own members. So the idea in number 5, which is coming up, is to send it to an independent special magistrate to remove it from the political process and prevent commissioners from voting against their own peers and having to hear forfeitures from their own peer group.
Okay, because I too am uncomfortable. I don't know a better word for the knowingly, but I just don't know that were any other words bandied about or discussed besides knowingly?
Yes, taking
to
out
try-
knowingly, so that just any violation of sunshine law, ethics law,
Well-
public records
well,
law would result in forfeiture.
Okay, it's always been the case that I've known so far in any of these coming before an ethics violation or a sunshine violation, that the judge in the case has, if he says it's probable cause, where does that come into it, I guess is my question. Probable cause.
The Ethics Commission can find you in violation even if it's not knowing. You can knowingly violate an ethics law. You might not have known you were supposed to fill out a form that disclosed your property interests, and you didn't fill it out correctly, you didn't knowingly do that, or you failed to report a contribution, you didn't know there was a form to fill out for attending a charity luncheon and accepting a gift or something. So it might be an unknowing violation.
Okay, since we do allow, I think that you had said that we allow 75 words in the ballot amendment, or the wording of the ballot amendment. Is it possible to maybe expand that, to expand it, okay, so that more people might understand it?
Explain.
Yeah, to explain it more, since we're allowed 75 words, somehow to reword it, because I guess I'm a little uncomfortable with it too, so.
We could add some words, and we may think about it between now and Thursday night about what words to add. I did want to note, although it's not a ballot question because it's not being changed, the current charter states forfeiture of office. A commissioner shall forfeit his office if he lacks at any time during his office any qualifications for the office prescribed by this charter or by law, except that any district commissioner who changes residence from one district to another during the course of his term of office, or the district boundaries are redrawn during the term of office, the district commissioner shall be permitted to serve out his term. I believe we've changed some of the gender and some of the other issues that'll come up in that section. B, violates any expressed prohibition of this charter. C, is convicted of a felony or a misdemeanor involving moral turpitude. Or D, fails to attend 4 consecutive regular meetings of the Board of Commissioners without being excused by the Board of Commissioners. And that's being addressed in our next ballot question, number 4, to go from 4 unexcused absences to 3 unexcused absences. So the important thing to remember there is right now, in terms of violations of laws, you would have to violate an express prohibition of the charter or be convicted of a felony or a misdemeanor involving moral turpitude. And this would be adding on another list. You'd have to, another ground for forfeiture would be violating sunshine law, ethics law, or public records law. That was discussed, and the committee decided to put the word knowingly in there so that an inadvertent violation of sunshine law or ethics law or public records law wouldn't result in a forfeiture of office. And it may be something you want to put in, or it may not be. I don't think most violations of sunshine law or public records law would involve moral turpitude. Some ethics law violations could involve moral turpitude depending on what the act was. For examples, moral turpitude, an ethics law could intersect where someone is accepting a bribe for a vote. That would clearly be moral turpitude. Or some forms of sexual harassment, some forms, knowing forms might be moral turpitude. But not all misdemeanors would be moral turpitude or all violations. So that's another thing to think about too. Let's move on now to question number 4, and think about question number 3 as we go to the workshop. Oh, there's a question in the back.
Bill Gay, 423 150th Avenue, Madeira Beach. Was there any reason why you left off the election violations?
Bill, would you flip the switch, please?
Is that okay? Was there any reason why election law violations were left off this particular ballot question?
I don't think there's any particular reason other than that election violations could probably also fall into the category of knowing or unknowing. Some of the election violations are the failure to put the disclaimer on the bottom of postcards, mailers, special events, fundraising activities, accepting donations that might exceed the amounts. That is another area of public official law that you could add in here. It could say sunshine laws, ethics laws, election laws, or public records laws.
During the last election, there was a violation of one of the candidates in which the Election Commission ruled that that person violated the election laws. I'm just asking the question.
That is another thing you could propose to the Board of Commissioners, to include election laws or to
I think so.
knowing election laws.
I think so, yes.
That is something you could bring forward at the workshop on Thursday. Any more on number 3? Number 4, forfeiture of office after 3 unexcused absences. This charter amendment would provide that a commissioner shall forfeit office if the commissioner fails to attend 3, parentheses, instead of 4, parentheses, consecutive regular scheduled meetings or regular scheduled workshop meetings without being excused by the Board of Commissioners. So this would lump meetings and workshops together, and if you had 3 unexcused consecutive meetings and workshops at which you were not excused, that would be grounds for forfeiture. Right now, it requires failure to attend 4 consecutive regular meetings of the Board of Commissioners without being excused by the Board of Commissioners. Any questions or comments on number 4? Ballot question number 5, forfeiture proceedings by special magistrate. This charter amendment would establish a forfeiture of office procedure referring forfeiture allegations against a Board of Commissioner to a public hearing held before a special magistrate who shall have the power to subpoena witnesses, administer oaths, and require production of evidence and make a final decision as to forfeiture of office that would then be subject to judicial review. Any questions, comments, or concerns regarding number 5? Number 6, adjustment of district boundaries every 5 years. This charter amendment would require that every 5 years, the Board of Commissioners shall by ordinance review and, if necessary, change the existing municipal district boundaries to ensure that each district shall be approximately equal in number of residents. Should the charter be amended, yes or no? The current charter required every 4 years, and we're moving this to every 5 years to be more commensurate with the census.
And I think, too, it was also just the simple fact that our boundaries are basically pretty static. And, yes, as we add developments and structures change, we want to be cognizant of it, but we just, again, housekeeping, taking out the year 1978 and doing some cleanup on the. Paul? You need to step up, sorry.
One 4091 North Bayshore. I thought where we say equal number of residents I thought we were talking electors.
I think we are. I think that's a mistake that should be corrected.
Thank you.
The charter itself, language, it says electors. Residents could be seasonal residents, and I think we only wanted electors who are registered voters.
Good catch.
That didn't change in the body, but in the introduction, when we moved the introductory sentence to the top, it inadvertently says residents. I believe it should say electors. Any other comments, questions, concerns regarding number 6? Moving on to ballot question number 7, collection of signatures to run for office. This charter amendment would amend the candidate qualifications to allow candidates to collect signatures of registered voters to run for office citywide instead of collecting signatures within their district, since candidates are elected at large throughout the city. The commission candidate would have to still reside in the municipal district to fill that district commission seat. Should the charter be amended, yes or no? Any comments, questions, or concerns regarding number 7? Ballot question number 8, adopt state law for recall procedures. This charter amendment would adopt the recall provisions set forth in Florida statute section 100.361, municipal recall. This would be a new charter section that would simply adopt state law. State law controls anyway. It may not be necessary, but the committee thought that it would be helpful within the charter to spell out the recall provisions so that anyone looking for the recall procedures would know which state statute to go look for. Any questions regarding number 8? Ballot question number 9, induction of newly elected commissioners. This charter amendment would require the induction of new Board of Commissioners and the appointment of vice mayor at the first regular or special meeting, which shall be held on or before the last day of the month in which the election was held. Rules of board procedure shall be adopted within 60 days following each election. So this was meant to ensure and change the existing charter. Instead of saying the first regular board meeting to be held after the election, it would be during the same month in which the election was held, not the following month. And it would give the commission a little more time, 60 days, instead of the first regular meeting to figure out what procedures they wanted to operate under as a new commission. Any questions, comments, or concerns regarding number 9? Yes.
Debbie Weinstein. I'm speaking as a citizen, and my address is 441 129th Avenue. With regards to ballot question 9, is it in the charter now, if you can look, because I don't have a copy of mine.
I have it in front of me.
Okay. Is it in the charter now that the position of vice mayor automatically go from one district to another? Or is that just been done procedurally by the commission?
I see.
I know it's not exactly pertinent to this, to the actual ballot question, but it is.
Section 4.4 addresses the vice mayor. It simply states the Board of Commissioners shall appoint a vice mayor at its first regular meeting following the election. The term of vice mayor shall be for 1 year. The vice mayor shall act as mayor during the absence or disability of the mayor. Should the vice mayor be required to act as mayor for a period in excess of 30 days, he or she shall receive the compensation of mayor retroactive to the date upon which he or she assumed the mayoral duties.
Okay, that answers my question, because I just wanted to make sure that it's the, yeah.
Charter does not limit a rotation or require a rotation. Any more questions regarding number 9? Ballot question number 10, remove city treasurer from the list of charter officers. This charter amendment would remove the city treasurer / finance director from the list of charter officers that are hired and fired by the Board of Commissioners, should the charter be amended. This charter amendment would place the city treasurer and finance director under the control of the city manager. Any comments, questions, or concerns regarding ballot question 10?
319 Boca Ciega Avenue in Madeira Beach. What prompted this? What prompted taking the city treasurer and finance director out from under the board and putting them under the city manager?
Well, you, Chairman, do you want to try to address that?
I think we throw it out to the committee as well. The way the city is structured with the city manager as being the officer that runs the city, it was convoluted that over here you have a finance director that's a charter officer, but sort of operating in the capacity of being quasi under the city manager. It was not a clear path. And then it sets up that the city commission was in a position that they could be giving direction to the finance director without the normal following of the flow chart of duties. I don't know how clear that is, but if anybody on the committee wants to jump in.
Right now, the city treasurer, finance director, and the city manager are both equal charter constitutional officers, charter officers that reported to the city board of commissioners. There was a little more convoluted hiring process with regard to the city treasurer, finance director. Let's see if I can find that. In existing charter section 6.4, the city finance director also in turn shall be the city treasurer. The director of finance shall be appointed by the city manager subject to the Board of Commissioners approval. So even though they were a city charter officer, instead of being appointed by the city commission itself, they were appointed by the city manager subject to approval by the Board of Commissioners, which was a little kind of a hybrid. Also, there could be, there was discussion in the city charter review committee that there could be differences of opinion regarding the budget, and it would be helpful to have one person recommending a budget, and that would be the city manager if this were to pass, not the city finance director or city treasurer. So this is purely really a matter of policy, how the city would be set up. This one would remove the city treasurer and finance director entirely from the charter, being addressed then by the code of ordinances and being under the city manager, who would hire and fire without being subject to the city commission, being subject only to the city manager. Any comments, questions, concerns regarding number 10? Ballot question number 11. Delete commission investigation procedure from charter. This charter amendment would amend the section of the charter containing investigations by the Board of Commissioners to state, the Board of Commissioners may make investigations into the affairs of the city by appointing a charter officer to investigate internal affairs of the city. This was streamlining and making more general the method of internal affairs investigations into city affairs. So how this would work is if the city commission decided to conduct some internal investigation, they would appoint either the city clerk, the city attorney, or the city manager to conduct the investigation. And that would allow them the flexibility if they were investigating the city attorney's office to appoint a city manager or city clerk to investigate. If it was the city clerk being investigated, to appoint the city attorney or the city manager to investigate. If it was the city manager being investigated, to appoint either the city clerk or the city attorney to conduct the investigation.
In lieu of having the commissioners
In lieu of having the
potentially
commissioners do it
doing it
themselves.
themselves. Can we go back to ballot question 10?
Okay.
Debbie, you made a good point about fleshing out some of the information. And I'm wondering if, John Q. Public picks this up and goes, well, who's going to be in charge of the city finances? Because we haven't really explained further in that initial paragraph. We're saying that we would remove them. But we're not saying how that continues to operate, how the office continues to operate in terms of it following under a department, correct?
So if this was removed from the charter, you could still have a city treasurer and a city finance director if you adopted an ordinance or had ordinances that created the position, which we have. In an organizational chart structure, the finance director, city treasurer would report directly to the city manager, who has the power to hire, fire, supervise all employees. And they would be simply an employee, not a charter officer, if the charter amendment were to pass.
I think
That would be the city
needs
treasurer would just be an employee, not a charter officer.
to have a more fleshed out explanation.
Ballot question 11. I think we read that one. Were there any questions on ballot 11? That was the internal affairs investigations. Moving on to ballot question number 12, special meetings called by city manager. This charter amendment would allow the city manager to call special meetings of the city board of commissioners, should the charter be amended. This would change the existing charter, which allows only the mayor or a majority of the commission members to call a special meeting. There may be occasion when there is an emergency like a hurricane, something to that effect, where the city manager needs to call a special meeting and can't reach the mayor or can't get a majority of the commission members. So this would allow the city manager to establish a time, date, and place for a special meeting. Any questions, comments, or concerns regarding number 12? Number 13, ballot question 13, special magistrate to replace Board of Adjustment. This charter amendment would replace the Board of Adjustment with a special magistrate, should the charter be amended. And in this case, the Board of Adjustments hears applications for variances and special exceptions. So these can then be heard by a special magistrate instead of a Board of Adjustment. Any comments, questions, or concerns regarding number 13? Question number 14, citizens' initiative and referendum procedures. This charter amendment would allow citizens to circulate petitions to propose, require, reconsider, or repeal ordinances. I think we should add in the word propose, adopt, require reconsideration or repeal of ordinances by initiative and referendum vote of the full electorate where not preempted by state law, with signatures of at least 10% rather than the current 25% of the total number of electors registered to vote in the last regular city election, should the charter be amended. So what this would do would change the number of signatures required to place a referendum or initiative on the ballot from 25% of the total number of electors registered to vote in the last regular city election to only 10%. So it would be easier to get on a ballot with an initiative or a referendum But you would still have to get the full majority vote of the electors at the actual referendum election. And you can propose ordinances, repeal ordinances, or require reconsideration of ordinances by initiative and referendum. That's in the existing charter. This would be simply changing the number, the percent of voters, which equates to a number of voters required to get it on the ballot, making it easier.
Resident Debbie?
Yes, Debbie Weinstein, 441 129th Avenue, and I'm speaking as a citizen. Did you all discuss anything other than that 10%, or did you just automatically go from that 25? I just think that 10% is, to my way of thinking as a citizen, I think I would want to work a little bit harder than that to determine whether it was in the best interest of the city, even to bring it forward to try and put it on a referendum.
We looked at other cities, research was done.
I think state law says 10% to change the charter by initiative or referendum, but I have to take a look at that. You could propose a different number if you had a number between 10 and 25. That could be changed.
But it is a state law, is it?
Only to change a charter, not to adopt an ordinance, require reconsideration or repeal of an ordinance that doesn't involve a state or a city charter. Okay. City charters, you can change a city charter by citizens initiative, which would be apart from this citizen charter review committee or apart from the Board of Commissioners. If anyone wants to propose their own question for the ballot and they were to obtain currently 25% under the city charter, but I believe it's 10% statewide under the Florida statutes, they could propose an amendment to the city charter. This was trying to bring the 25 back in line with the state statute requirement.
Okay.
Charters, that's where we got 10%, I believe, and I can check that before Thursday.
There were also other clarifications made in this paragraph because of discrepancies in the past, that there were items that were unclear on how things had been handled, and so some of the wording was changed so the definitions or the meanings of circulator, person obtaining signatures, and that was reworded so that there wasn't, it was made to, we hope to make it more clear.
We should probably add that to the ballot question itself, because we don't have anything in there about that. And procedure to designate a petitioner's committee. And circulators. Mm-hmm. Apparently, in the history of the city prior to my being here, there was an issue with a petition that was circulated and the city attorney disallowed based on not having the circulator's presence or the committee registered.
Affidavits of the circulators themselves, which was onerous to expect a particular person to be the obtainer of an affidavit signer, that all of those were just by
that one person that started.
Yes.
So this way, the committee would shall designate persons. It would state the petitioners committee shall designate persons who are registered voters in the city, known as circulators, to obtain signatures on the petition forms. Each paper of a petition shall have attached to it, when filed, an affidavit executed by the circulator thereof, stating that the circulator personally circulated the paper, the number of signatures thereon, and that all the signatures were affixed in the circulator's presence, that the circulator believes them to all be genuine signatures of the persons whose names they purport to be, and that each signer is an elector of the city, and had an opportunity before signing to read the full text of the ordinance proposed or sought to be reconsidered. And then those signatures would then be verified by the supervisor of elections. So it would also add in that procedure to designate a circulator, designate one or more circulators to collect signatures. Any other comments, questions, or concerns regarding number 14? Ballot question number 15, there's actually two alternatives. There was a split of opinion on the committee, which was actually also a split between the Charter Committee and the Civil Service Board, which had a joint, or Civil Service Commission, which had a joint meeting with the Charter Review Committee regarding the Personnel Systems Civil Service Commission. So what is going to the workshop on Thursday for discussion are two separate proposals. There's Alternative 1 and Alternative 2. Alternative 1 would state, this charter amendment would retain the Civil Service Commission the power to issue advisory opinions on employee grievances and the ability to inquire into the implementation of such personnel rules as considered necessary to ensure compliance, but remove other references from the charter, merit, principle, and personnel rules from the charter. You should say remove other references to merit, principle, and personnel rules from the charter. Let me read that one again to correct that typo there. This charter amendment would retain the Civil Service Commission and its power to issue advisory opinions on employee grievances and the ability to inquire into the implementation of such personnel rules as considered necessary to ensure compliance, but remove other references to merit, principle, and personnel rules from the charter. Those could still be within a personnel handbook, which is adopted by ordinance, but would be removed from the charter. So the charter language below it shows you what would remain. You would have B, creating the Civil Service Commission, D, the duties and powers of the Civil Service Commission, and then E, retaining the powers to collectively bargain recognized. Those aren't affected. And then Alternative 2, there's a typo also on Alternative 1, because we wanted to keep in 6, the grievance procedures, based on an advisory recommendation. So 6 is shown as stricken through. It should not have been stricken. In the alternative number 1 that was recommended by the Charter Review Committee. So in Alternative 1, the idea was that you would retain a Civil Service Commission and they would have grievance procedures and hearings, and they would review personnel rules to ensure they're being properly implemented. I think we could make that language that we have on the ballot question a little bit more simple to state just that. This charter amendment would retain the Civil Service Commission, retain its ability to hold grievance hearings and render advisory opinions, and retain its ability to inquire into the implementation of personnel rules. And then leave it at that. I think that would be much more simple language than the language that's on this paper. Go ahead and speak into the microphone so everyone can hear you.
I'm looking at my notes, and we had talked about that paragraph 6, and there was a note as to amending 5.4.1. We were going to-
For this alternative, you are simply making an advisory opinion to the city manager, so you would not need to amend the city manager's power to hire and fire employees. That would come in alternative 2.
Which isn't in there, but
5.4.1 is the power to hire and fire. That would be amended in alternative 2.
okay.
So alternative 2 for ballot question 15 would retain the Civil Service Commission. It would limit grievance hearings to grievance procedures for terminations, not discipline, but would allow the Civil Service Commission to render a final decision with regard to termination of employees. And that would include then amending 5.4C 1, that would amend the powers and duties of the city manager to make them subject to the Civil Service Commission power to hear and issue final binding decisions by the Civil Service Commission on grievances of terminations. That shows up on page 22 of the papers that you have in front of you. Page 20. That's the city manager, changing the city manager to remove his power to hire and fire employees and giving the Civil Service Commission the power to fire employees. So the language that we have in alternative 2 currently, this charter amendment would give the Civil Service Commission the power to issue final decisions on employee termination grievances and remove the city manager's power to issue final decisions to terminate employees and remove other references from the charter merit principle and personnel rules from the charter. I think you would also still retain I guess that was it. We might be able to clarify that language too, to make sure that the voter at the ballot box understands this is with a change that would be proposed with regard to terminating employees would no longer be within the sole and exclusive power of the city manager. Any termination would go to the Civil Service Commission as a grievance, and they could overrule the city manager and issue a final decision. Any comments, questions, or concerns regarding ballot question 15, either alternative or any other alternatives or ideas or proposals?
Linda Hine, 401 150th Avenue. How do other cities around here handle this? Is there any other city that has final say with the Civil Service Commission, or how does that work?
We have a list. I don't have it with us, but some of the island cities on this Barrier Island chain don't have civil service boards. Other cities do have civil service boards. So it really is up to each individual city to determine how they want to handle this.
Do you know of any other city that has a Civil Service Commission able to override the termination made by the city manager?
I think the city clerk compiled a list of cities that have civil service boards. The city manager's office has also compiled a list of cities in the area that don't have civil service boards at all, that leave it up to the city manager. We can prepare and bring those memorandums to the Thursday workshop. They were distributed previously to the Charter Review Committee and to the Civil Service Commission to take a look at. So they have some memos on that.
Okay.
Yeah, it really runs the whole gambit. It's very diverse, from Jacksonville to Tampa to smaller cities that don't have the boards like St. Pete Beach. So it runs a whole gambit. Some of them have final authority, some have advisory authority, and other cities don't have them at all.
Okay, thank you.
Any other comments, questions, or concerns? Thank you on 15.
Avenue here in Madeira Beach. Just my 2 cents. I think these need to be kind of merged. First of all, our city manager needs to be able to terminate employees. That's crazy talk. We're not letting him do that. But I do agree that once the termination is done, a civil service board can review the decision. I don't think the civil service board should review discipline. So that's kind of my merging of the two. But what I really came up here to talk about is why in both of these proposals, we take out the merit principle, where we are now saying we're not going to hire and promote based on merit and fitness demonstrated. So what are you going to hire and promote based on? Seniority or something like horrible like that?
I think the committee
obviously
took it out because they thought it was obvious it did need to be in there, but it may need to be rethought. Maybe the general public would think, well, maybe that does need to stay in there. What does the committee think on that? What was the reasoning that it was taken out? I'm not sure I was there for that particular meeting. I think Matthew was there for A. I guess it seems kind of self-evident or obvious, but it was in there. When you take it out, maybe, was there a reason to take it out, or was it just they thought that it was self-evident?
Well, I just think the best person for the job, regardless. I don't know what else you can rely on besides merit and fitness demonstrated by the person's competence. I mean, the only other thing I could think of to put in there, if you take those two out, would be seniority, which would be something I would certainly not promote or vote in. I just think that needs to be put back in front and center so that our employees know it as well.
Thank you.
All right, that's it.
Are there not under HR, and that was one of the discussions, is that none of us are HR experts, whether we're, when a person is a volunteer, you're not necessarily an expert on these types of things. So I'm just wondering, is there not something under current guidelines that there are, as you just said, another formula, or is there something that is
Well, the collective bargaining agreements can say seniority trumps talent, believe it or not.
Yeah.
Or it's been interpreted to mean that. And I don't think we want to go down that road, that's all. So my concern was, why take out A at all? I think keep that in its entirety. I mean, that would help the bargaining if somebody had to do some collective bargaining. All right, that's it. Thank you. I thought this was very thoughtful and thought out, all the 15 questions here. I appreciate it. To all the people that did that, I mean, it cannot be easy.
Any other questions on number 15? Okay, I think you can conclude the meeting if you'd like. I encourage everyone to come to the meeting, the workshop on Thursday at 6 p.m. When the Board of Commissioners will consider the questions. I'll put in some of the changes that we came to today, if that's okay with the committee. And we take
There's agendas on the back table if anyone would like one for Thursday's meeting.
So,
one more comment?
one more public comment?
Linda Hine, 401 150th Avenue. I just want to say, as a citizen, I think it would be awesome if you could clarify some of these charter amendments as to what is happening and what you expect. So anyway, some of the ways you talk, maybe there's other ones you could clarify. It's a whole lot easier when you're looking at them and you weren't at a meeting like this. I didn't understand what some of them were, and now they're clear. But if there's some wording you could add that would make it a little bit easier to understand, makes more sense. So anyway, thank you.
Thank you. We will have this workshop and then 2 more public hearing readings at the Board of Commissioners, and so we hope to work on the language as we go along. So anything you think of as a suggestion for better language, go ahead and jot it on a piece of paper and bring it up at those hearings if you can. Thank you.
These are posted in the city website with further explanations so that people who, as you say, aren't attending can read through that and see more explanation.
And you can print them out and bring them to the meetings too. I think we don't have a layperson's guide yet for these particular ones, but the paper that you have with you today, that's available on the city's website.
So if there's no further comment, it will adjourn the meeting at 7:12. Thank you all for being here.